One of the many extraordinary measures taken by the federal government in response to the COVID-19 pandemic is the issuance of blanket waivers of certain provisions of the Stark Law, the federal law that prohibits physician self-referrals. Here are 3 best practices for applying the waivers. First, don't abandon the familiar analytical framework. The blanket waivers do not fundamentally alter the way in which financial relationships should be analyzed. There's a natural temptation to zero in on the conduct permitted by the blanket waivers without considering the surrounding context. But financial relationships must satisfy all of the non-waived requirements of an applicable exception to avoid a violation. Second, document. Although hospitals, physicians, and other healthcare providers may use the blanket waivers without the submission of specific documentation or advance notice to the government, they are required to make records relating to the use of the waivers available to the Secretary of HHS upon request. Third, enter with an exit plan. The blanket waivers were issued on March 30th, and they're effective as of March 1st, but they will end in accordance with Section 1135 of the Social Security Act, which in all likelihood means they will end upon the termination of the presidential declaration of an emergency or the Secretary's determination of a public health emergency. Parties relying on a waiver should plan to get out before they get in. The Stark Law is, after all, a strict liability law. If the parties continue to maintain a financial relationship that was compliant during the emergency period only by virtue of the application of the waivers, the parties will, following the end of the public health emergency, be parties to a non-compliant financial relationship.